morning. I've been introduced. To my right is, we've got Judge Harris, and to my left is Judge McIver. We've got one matter on the calendar this morning, and that's the Howard versus State case with an order to appear for Attorney Michael, is it Konageski? Konageski. Okay, will you please come forward? To the lectern there. You get the hot seat without a chair. Raise your right hand, please. Do you solemnly swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, great. Okay, we're here on case number 5D 2026-1889, and it's also related to case 2025-1950, Calvin Howard versus the state of Florida. And we're here on an order to appear and show further cause. Just to make sure I have everything right here, in the underlying case, was that in Hernando County?
Yes, sir.
In Hernando County, that course case number 2016 CF 002111-A. You were representing Mr. Howard. Was it in the 3850?
Yes, sir. I was court appointed after an order from this court to have a evidentiary hearing.
Okay.
So I was appointed to have or represent him for that hearing.
All right. And in our case 25-1950, when you filed the notice of appeal, and I don't know if you've gone back to take a look at it, but the notice of appeal is not signed.
Okay. Yeah.
Your Florida bar number is not on there.
Oh, okay.
And you have that you served it on the Attorney General and the State Attorney, but you didn't include an address for either one of them.
Yes, sir.
Our court sent out an order July 1, 2025 saying there's a problem with your notice of appeal, you need to fix it. And it shows that you are copied on that.
Yes, sir.
You didn't respond. You didn't file an amended notice of appeal. And so the court then on July 16, 2025 sent out another order saying why should Mr. Howard's appeal, not your appeal, his appeal, not be dismissed, copied to you, and you had time, 10 days to respond, and you did not respond to that either.
Yes, sir.
Then on July 31, Mr. Howard's appeal was dismissed. You were copied on that order as well. Apparently you didn't take any action.
And
The reason I say that is because the next thing we know is sometime later, Mr. Howard, who I'm assuming is sitting in prison,
yes, sir.
is wondering what's going on with his appeal. And so he has to file a petition for a belated appeal. And in that, he says he wrote you several letters wanting to know what happened with his 3850 hearing, and you never responded. And he says that after several months passed without getting a response to you, he wrote a letter to the judge, and the judge sent him an order denying his motion to rule or whatever it was, saying, I already ruled on this, and we sent you a copy, care of your lawyer. And then we get a response for the petition for belated appeal from the Assistant Attorney General who's handling the case, telling us, yeah, as she should, and she's very professional, that yeah, it's not Mr. Howard's fault that his appeal got dismissed, it's his lawyer's fault, and here's a good remedy for it. And she was kind enough to us and maybe not so kind to you, but I think in the long run, it's going to be good for you that she did this, to advise us that you had the same thing going on in another case, and that case is Anthony Hancock versus the state of Florida, which we're technically not involved with here today, except you did the same thing there. The clerk's office sent you an order, you ignored it. An order to show cause, you ignored it. The case was dismissed by order, and you ignored that too. So that's basically 6 orders from this court that you've ignored, and it's quite hard for us to understand why when you get court orders. One, falling in the cracks, you can kind of understand. Two, something's wrong. Six, explain that to me, please.
Best explanation I can give, judges, I have no recollection of seeing those orders. That's not a fault of anybody besides myself. My office and I have both went through every single email that I can to go back as far as I could to see where or how I may have missed those. I cannot find them. I have no reasonable explanation for that because I do get court orders from every court that I appear in, including the 3 counties that I usually work in over in the 5th Circuit. Even today, the order that you had asked me to respond to, I got a copy of that from a deputy clerk in this district court asking me if I was going to respond. That's the first time I ever saw it. And then I immediately responded, actually that afternoon, and have since tried to stay up to it. These cases, I remember both of them very well. I remember both clients asking me, specifically to Mr. Howard. I sent a copy of the, basically denial to him before he left at the county jail to go back to prison. I have not received any letters besides one that I had thought I'd already answered by sending him a copy of that. I had been in contact with Mr. Hancock's family. That's why the appeal was provided. I had not gotten any contact from them after that. That's what I tried to explain is I wish I could tell you what happened. This is never my intention. I never meant to come here or never would like to be here, quite frankly, to be explaining myself for something that is fairly correctable.
Well, I'm not a software guru by any means, but if you haven't had somebody look at your system, you certainly would be well advised to.
So I actually got a new computer in 2025 because I had such problems with, once we started getting body-worn cameras, my space on my computer really started dwindling down. So I had to fix that problem. I got a new computer, got a new system set up so I can actually download these massive files that come in. I wish I could say that's the reason, but realistically, I can't say it is. Actually, I had to get my staff a new computer not too long ago because the same thing was happening where we were having difficulty downloading emails because our space was taken up with everything else. We have since rectified that situation. We now have cloud space, Dropbox programs and things of that nature. So things are a lot more streamlined as far as I can tell, but I don't like that explanation that it's just an oversight. I mean, I would never have done that to either one of those clients. I spent a lot of time with Mr. Hancock prior to his plea. I knew he wanted or was, unsatisfied, so to speak, of the fact that he had to go to prison for his sentence. Mr. Howard came to me already serving a very lengthy, serving life in prison. He had a reasonable motion for post-conviction relief with new evidence. We were able to present that evidence to the judge, and while the judge did deny it, I certainly would have liked the opportunity for Mr. Howard to appeal that because I felt like that was something that was appealable. I mean, I know it is under the rule.
I want to let you know that our court did reinstate both clients' appeals. You also do some civil work. You do family law work, correct?
Very few, but yes, sir.
I looked at your website.
Yes. It's on there. Yeah.
You say you do family law work.
I pick and choose. I have a lot of criminal cases.
Okay. The reason I'm bringing up the civil side, it's not as easy to get a civil case reinstated as it is a criminal case because criminal defendants have the constitutional right to effective assistance of counsel. Unfortunately, civil litigants don't. So if you had gotten an order in any of your cases in a civil case that you didn't respond to and their appeal got dismissed, it's a much tougher battle there. I mean, this is unfortunate here. And again, I'm not here and we're not here on the Hancock case, but I'm going to give you some very friendly advice here. And I'm looking at the response that you filed July 30 in the Hancock case, which is case 243461. I'm looking in paragraph 2. The panel there asked you to tell them what you would do in the future to avoid this problem. And you said, to ensure compliance regardless of the representation status, my office will forward all correspondence from the 5th to me, and I will communicate with the public defender's office or respond to the court directly. Let me give you some advice. You get a court order from this court again, you had better, you yourself, respond. You don't want to come back over here and go, I talked to Cindy Lou Who at the Public Defender's Office, but I didn't think I had to respond to an order from this court.
Of course.
You understand me?
You do, and the reason that actually was a kind of an unfortunate response that I can see now why I said it. The main reason why is because I don't have that many cases currently up on appeal, but one of them that I do have just currently started the process maybe a few months ago, and I have been in contact with the Public Defender's Office because they were assisting in getting the file, because most of these clients, actually all of them, are court appointed, so I want to ensure that they have representation for that appeal, so I usually help with them.
And I'm not telling you not to talk to the Public Defender's Office. That's fine. I mean, the quicker you can get it solved, the quicker you can make sure they're on the case, that's fine. But you get an order from this court or any other court, you respond to the order. Your response can be, I'm not on the case anymore. The public defender's supposed to be. I double-checked. I talked to Cindy Lou Who at the public defender, and they're going to get right on it, and a copy of your response goes to the public defender's office. But not responding to an order is inexcusable.
I completely agree.
And we really can't have that. What I'm going to suggest, we'll meet after this to conference the case, but I don't know if you've gone back through the last couple of years of your cases where you were trial counsel or hearing counsel, just to please make sure that indeed the handoff occurred and that the public defender or whoever the appellate counsel really got involved, because not every criminal defendant who's spending a lot of time in prison necessarily has the wherewithal, either through law clerks or their own ability, to figure out that their appeal didn't go forward. And they may still be sitting in prison, may or may not have a good case, don't know, but they have the right to go forward with their appeal, and they need to know that. So in our order to show cause, not the one to appear, but to show cause, we asked you to explain in that what had gone on in the Hancock case. You didn't address it at all in that response to us in this case. Again, there's different panels.
Sure.
I know you filed responses with them because you have the great fortune of Judge McIvers on both panels.
Yes, sir.
But again, when the court orders you, and it's not asking you if you feel like it, anything else, we order you because we want to know. We've had lawyers before, as I say, sometimes one or two things fall in a crack, and if they don't fix it, then we have them come over here. We've had other attorneys who've had 7 or 8 cases either get dismissed or get strung out, and then they file a 4-page brief that you can describe in whatever terms you would like to, and their clients are not getting properly served. And we brought one of those attorneys over here, and by researching it, he had 8 or 10 cases like that. And not just in our court, but in other courts. We don't want to see that. We're not here because we have nothing better to do or want to chew you out or anything like that, but this is not how you practice law. This is not how you do a good job for your clients. We don't operate well when we have to go to these lengths to let somebody have their appeal go forward, because now, because of you, 2 people got their cases dismissed, and I can't imagine how that would feel. And we have a total of 4 cases where we should have 2.
Yes, sir.
And you know, you need to ensure, and with your office staff, need to ensure that that doesn't happen again. And again, I will say, I know software problems can happen. That may or may not have been the problem here. But you need to, I would encourage you, unless you're a software genius, I would encourage you to get somebody to take a look at that who does know, and to make sure that these things aren't going off into the ether somehow.
Yes, sir. Because
if it happens again, you know, it's not going to be any more fun than this one, I can tell you. And you know, we're officers of not just this court, just like you are. We're officers to ensure, and we're under the Code of Judicial Responsibility. If we see an attorney commit what appears to be an offense under the Florida bar rules, we're to take appropriate action.
Yes, sir.
If this is enough appropriate action, that's fine. If it needs something more, we've done more. So that's what I have to tell you, and I would, any further response from you, I'd be happy to entertain.
It's more, I mean, all I can do is apologize. I've never not responded to any court order from any of the, county court or circuit courts that I appear before. I wish I could say it all falls on me. I mean, it's absolutely my fault. I certainly would never have wanted anything for Mr. Howard or Mr. Hancock to not have the option to at least appeal their rulings or their sentences. Like I said, I spent a great deal of time with both of them, so I would never want them to not have the avenues that are appropriate for them to have after their case is concluded in the circuit court. Since the receiving of these orders, I have done everything I can to try to answer how I thought it might have happened, but to this day, the answer literally sits with, I don't know. I don't know why or how, and I don't, yes, sir.
So, on reading this case, my sort of rebuttable presumption was, you thought the case was with someone else, inadvertently you hadn't been taken off of a service list, so you see these things coming in, you're still getting the emails, they don't apply to you and you were ignoring them. That was my, like I said, rebuttable presumption. A venial sin, a sin nonetheless. What you're expressing to us here today, and I'll tell you, at least for my part, I don't doubt your veracity. It is less troubling from a culpability aspect, but slightly more troubling from a how do you fix it aspect. If I don't know what the problem is, I don't know how to fix it. So in addition to Judge Edwards' suggestion, I know we have so much extra spare time in our day, but you did say you don't have a lot of cases on appeal. One suggestion I would make is I think if you do have cases that are before any of the district courts, you need to add a periodic docket review in each of those cases to your normal routine. Start checking the docket until you know what happened. Start checking the docket once a week and make sure you're not missing things.
I can't say, I mean, when I first started on my own private practice back in 2018, this was the practice I was explained for court-appointed counsels, that I work with the public defender's office to ensure my clients get the appointment of the public defender over here so that they have an appropriate counsel to represent them. Usually, I'll receive something from an attorney over here indicating they've got the case, it's been assigned to them. And then once that happens, they ask me things like, hey, do you have any information about this particular defendant or these particular rulings? I will try to stay in communication with them. Obviously, with Mr. Howard and Mr. Hancock, neither one of them got that specific appointment. And that should have been a red flag for me because it does usually happen sometime within the first couple of months after I filed my paperwork. But again, that inner working process was kind of not known to me other than just that it happens. I know right now that these two, and then there's another gentleman who I've been working with. I mean, he and we just had a hearing in the circuit court on that case, so I have tried to stay in touch with that case and on top of that particular aspect to ensure that I don't have any, I don't know why.
You may also want to ensure that each court has your proper email information.
I will say the orders that I received even today just had my name on it without where it went, so I did go back and look. Now, up until a couple of weeks ago, neither Mr. Hancock or Mr. Howard's cases appeared in my portal as cases that I was either assigned to, attached to, or had filed in on. So I didn't have access. I still don't really have access to those cases, at least in the court portal. I can file, but I can't access the actual docket itself. I have tried to stay, I mean, certainly with these two clients specifically, given their current circumstances, I'll certainly stay in touch with them and on top of their specific information to ensure that they have counsel going forward or anything I can do to make sure that their appeals get heard.
Did you get in touch with Mr. Howard or Mr. Hancock either personally or by correspondence to let them know?
I have let them know. From what I know, my office has sent over all the responses that we have provided to them to let them know that at least their appeals have been reinstated and that we would ensure that we could do anything we could to try to make sure that their stuff gets where it needs to go. It concerns me that Mr. Howard has indicated he sent me several letters. The only letter I received from Mr. Howard when he got to the Department of Corrections was there was an inquiry about his appeal, but it was more about, a lot of times I get these letters that people are asking for a reduction in sentence or a modification or some sort of 3800 type ruling. unfortunately for Mr. Howard, he's way out. I mean, he's been serving his sentence for quite
Do you know whether Mr. Howard and Mr. Hancock have appellate counsel now who have appeared?
I don't believe either one of them have it as of now, because both of their appeals have been reinstated. I have not seen that actual paperwork going to where it needs to go, so I will ensure that I'll try to stay on top of that to make sure that it does happen for them.
Okay, but you are monitoring that and doing what you can to ensure that if it's the public defender or whoever else, that they get appointed?
Yes, I mean, I know that neither one of them are going to hire their own counsel, so I will ensure, and that was one of the things I did talk to the public defender's office about these, just to make sure that I'm not missing something that gets to them so they can get it, because they've always been the party that has helped me get the appointment of the public defender over here. And so I certainly try to stay in touch with them. I get the answer kind of sounded like I was deferring to them and not me. I certainly know the rule requires me to continue to stay on the case until such time as I think it's taken up by this court. And normally I will get an order or something from this court indicating that there's a new case now in the 5th District Court of Appeals for a previous client of mine. To that extent, I usually try to stay in touch with them. Most of my cases now have been resolved. I think there's only 3 here currently.
My colleagues, anything further?
You do appreciate the number of appeals that we get in this court every year, right?
Yes, sir. I mean, I can only imagine.
It's very rare that we do this. In the 8 years I've been here, I think this is the second one. So you need to understand that we take this very seriously, and I hope you do as well.
Absolutely. I've had a very difficult time. I mean, like I said, I've never had an order to show before a judge for any reason other than for a court case or a court date or something to that effect. So this was very unsettling to me, as this is not a court I ever expected to appear in unless I was unfortunately ordered to appear in here. So this has not been a fun experience for me since the order came out. I very much...
It's not a fun experience for us either. We don't enjoy doing this.
And I understand that. I wish I could have explained it better in an email or a motion or things like that, but I don't have a way to explain anything more than what kind of like the normal process and how I would kind of...
The Florida Bar does have a very robust practice management section, assistance available to you. If you think that might be of some benefit to you, I would encourage you to reach out because, again, as Judge McIver said, if you're not sure what happened, how can you be sure you've got it fixed?
I mean, I did check, I checked to see if the Florida Bar, all the information's on there because that's where my email e-service usually comes from clients and things. I know my name is a little confusing to spell, but it's not that difficult, so I can only assume that it's on my end, not anybody else's. And certainly since I'm here, it's definitely my responsibility to do these things correctly.
All right. Anything else? All right, thank you. That concludes the hearing. We'll be in recess.
Thank you.